So that's reasonableness. So let's continue. However, and now they add conditions. So this first sentence is properly understood as referring to only, well, as a condition for either non-deadly defensive force and deadly defensive force. So before you're privileged to use force against another person to protect yourself or a third person, you have to reasonably believe that you're facing imminent use of unlawful force by that person you're using your own defensive force against. But that's enough to justify non-deadly force in self-defense. But if you want to use deadly force in self-defense, there are additional conditions. However, a person is justified in using deadly force and does not have a duty to retreat if the person reasonably believes, reasonableness again, that force is necessary to prevent serious bodily injury to yourself or the third person or the commission of a forcible felony. And a forcible felony is typically a felony that involves a threat of harm to persons, like a robbery, an armed robbery, for example. So what are the elements we have here? Well, is justified in using deadly force. Now that we're referring to deadly force, we're talking about the element of proportionality, the distinction between whether we're in the non-deadly force bucket or the deadly force bucket. If you're only being threatened with non-deadly force, you can only use non-deadly force in self-defense. You can't use deadly defensive force until you're facing a deadly force threat. So you're justified in using deadly force to prevent serious bodily injury. That's proportionality. And serious bodily injury is typically, that's part of the deadly force bucket. So deadly force includes force, not just force that can kill you, but force that can kill you or cause serious bodily injury. Some states call this grave bodily harm, grave physical harm, serious physical harm. They all have a three-word phrase for this concept of something more than a modest injury. And typically it's a maiming injury, blinding, loss of a bodily function, permanent scarring, loss of consciousness, rape, kidnapping would be included here. Even if there's no death, it's still deadly force. It's in the deadly force bucket because it's serious bodily injury. So you're justified in using deadly force only if you're facing a deadly force threat, meaning death or serious bodily injury. Of course, death itself is serious bodily injury. Or a forcible felony. Again, a felony that implicitly has a threat of violence against a person. Because there are lots of felonies that don't, right? So someone writes a bad check over a certain dollar amount, it's a felony, but it's not a forcible felony. And they refer to does not have a duty to retreat in the context of deadly defensive force. That's addressing the element of avoidance. So now we have reasonableness. We have deadly force, so proportionality. We have no duty to retreat, so we have avoidance. And we also have reference to innocence. So the force you're defending yourself against is an unlawful force, not a lawful force. So someone else is being the unlawful, criminal, initial aggressor in the confrontation, not you. If you're defending yourself against lawful force, like a police officer making a lawful arrest of you, using force to do that, he may be the first to use force, but his force is lawful, so he's not triggering your self-defense privilege. Continuing. And here, they're using the word necessary here. This is really a reference to imminent, the element of imminence. Imminence means that the unlawful force you're defending against is either actually occurring or immediately about to occur. That's what makes the defensive force necessary. So it's not a past threat that's already over. Someone punched you yesterday. You can't use defensive force against them today because of yesterday's punch. It can't be a future speculative threat that may never happen. Someone says, I'm going to go home and come back here with a gun and shoot you. Well, when he comes back with a gun, he's an imminent deadly force threat. But just the statement that he intends to do that at some point in the future, that in that moment, it's not an imminent threat. Indiana's referencing that element by using the term necessary here. Because if the threat's over in the past, it's not necessary to defend against it. If the threat's speculative in the future may never happen, it's not in the moment necessary to defend against it. And then it continues, no person, employer, or estate of a person in the state shall be placed in legal jeopardy of any kind for protecting themselves or a third person by reasonable means necessary. This is kind of circular reasoning. It's saying We just defined self-defense, and if your use of force was lawful self-defense, you shouldn't face legal jeopardy. But how do you decide if it was legal self-defense, right? The process of inquiring whether or not your conduct falls within the legal boundaries, that's inherently legal jeopardy, right? It's a trial. So it's kind of circular. Paragraph D. A person is justified in using reasonable force, including deadly force, against another person and does not have a duty to retreat if the person reasonably believes that the force is necessary to prevent or terminate the other's unlawful entry or attack on the person's dwelling, curtilage, or occupied motor vehicle. So this is the defense of highly defensible property provision. And how's it defining highly defensible property? Dwelling, curtilage. Curtilage is the area around your home, immediately around your home. That's part of the normal day-to-day function of your home. So it's extending the scope of highly defensible property outside the four walls of your home to like your front porch, your back porch, your front yard, your backyard. If you live on 50 acres, the 50th acre is probably not going to be curtilage. It becomes, there's no bright line that limits or defines the scope of the curtilage. It's done on a case-by-case basis. So you never really know if you're standing in your curtilage or not, for the most part. Some states will say it includes your front porch, your back porch, and the area around your home that's part of the day-to-day use of your home. So sometimes it provides some objective criteria, but ultimately the far boundary of your curtilage is generally not sharply defined. Except that once you reach a point from your home where you no longer have the right of exclusion, so it's like a public street, your curtilage is definitely done then because other people have a right to be there. So your dwelling, the curtilage around your dwelling, or an occupied motor vehicle. So an unoccupied motor vehicle is personal property. And in 49 states, including Indiana, you can only use non-deadly force at most in defense of personal property items, like a cell phone or a purse or an unoccupied vehicle. But if the vehicle's occupied, suddenly it becomes highly defensible property. Why? Because really the real definition of highly defensible property is it's property that serves as a core function, the shelter and protection of people. And if there's people inside the vehicle, that's what the vehicle's doing. So dwelling, curtilage, and occupied motor vehicle is the scope of highly defensible property under Indiana law. And it provides that you can use deadly force to prevent or terminate some other's unlawful entry or attack on that highly defensible property. Now, attack suggests forcible, right? Certainly, someone's going to, they have a lit Molotov cocktail in their hand. They're going to throw it through the window of your home. I would consider that an imminent attack on the dwelling. But it also says, or unlawful entry. Most states that have these provisions that allow you to use deadly force in the context of highly defensible property require both unlawful entry, so someone's not there by license, they're there without permission, they're trespassing, and a forcible entry. So they broke something to get in. They usually require both unlawful and forcible entry. Why do they do that? Because they're concerned about the innocent intruder, someone who's present unlawfully, but without malice. They're there unlawfully by accident. They mistakenly think they have permission. They were a repairman sent to the wrong address, or they're an out-of-town visitor that walks into the wrong apartment in the apartment block. And the law often doesn't want to create these special provisions for the use of deadly force against the innocent intruder. But Indiana doesn't require both, either unlawful entry or an attack on the dwelling, curtilage, occupied vehicle is sufficient to trigger this privilege to use deadly force in defense of highly defensible property. So a broader privilege than the states that require both unlawful entry and forcible entry.